Welcome, Representative Greenman. I will move to recommend that House File 3456 be placed on the general register. I understand you also have an A6 amendment. Do you want to do the A6 first? Okay. So I will move the A6. Representative Greenman, if you want to explain the need for the amendment.
Thank you, Madam Chair. And this amendment, which was a very similar amendment, was adopted in the Senate, makes this bill not retroactive to contracts that currently exist, and adds for current contracts that currently exist a requirement that folks provide notice to employees of the law and the provision in the contract.
All right. Any discussion to the A6? All right. All those in favor, please say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Representative Greenman, to your bill as amended.
Thank you, Madam Chair, and I am grateful to be back in Judiciary to present this bill, which is about prohibiting restrictive employment covenants in service contracts. It closes a loophole to ensure that Minnesota's prohibition on non-competes and no-poach agreements is not evaded in service contracts that are signed above the heads and often without the knowledge or consent of the workers being impacted. Restrictive employment agreements like this, non-competes and others, are found in service contracts that include prohibitions on workers and are barriers to the freedom to work and fair competition. They restrict workers from being able to seek better wages and working conditions, and they limit workers' career growth within an industry. And we talked a lot about this last session, but just one note, the FTC estimated that clauses like this deprive American workers of between $250 billion and $296 billion a year in income. Last session, we took a big step forward in protecting workers in this arena, and this bill is about closing a loophole to make sure all workers have access to those protections. We passed those bills last year with a clear intent of protecting Minnesota workers from the practice of using restrictive employment covenants to limit the freedom of movement and opportunity for workers. But this summer, we found and learned of practices, the shadow non-compete, where companies are including restrictive employment provisions in contracts between two parties that don't include the worker. They have the same impact as a non-compete, limiting those job prospects, wages, career growth, but they're worse because workers don't often know about them. So what this bill does is simple. It says you cannot restrict or prohibit a customer from hiring an employee of the service worker. You'll hear from one testifier. We heard a lot of testimony in labor about this from I think 7 or 8 workers, but we'll have one. And this loophole closer is modeled on the prohibition of no-poach agreements, which you may be familiar with because that came through your committee last year. 2 entities can't contract with an employment restriction. So with that, I'd say, members, this is an important bill to ensure that the protections that we passed last year apply to all workers, often low-wage workers or workers who may not know this exists. And with that, Madam Chair, I think of one testifier and whoever else has signed up.
Yep. You have a couple people signed up. First up, I have Brian Shea, and then I have Jeff Tollefson on deck. When I tell you you're on deck, that means get closer to the table so we don't waste time with you walking around. Welcome to the committee. Mr. Shea, please introduce yourself and go ahead with your testimony.
Good morning. My name is Brian. Pardon me. My name is Brian Shea. I worked 6 years for First Service Residential Minnesota, most of those years as the overnight desk attendant at Gallery Tower here in St. Paul. In April 2023, coworkers and I learned about First Service Residential's restrictive covenants from an article in the American Prospect, not from our employer. Wanting to know how many of us were affected, we organized a petition. There was a telling difficulty in collecting signatures. What we were describing made no sense to people. It made no sense that there would be a restriction on their employment that they had never heard of or agreed to. All right? It didn't make sense that these covenants could exist and we couldn't point to them because we're not parties to the contracts. All right? So eventually, despite that, we got 48 coworkers to sign our petition, ask management how many of us were affected by the covenants. Management would not answer. Another desk attendant, Josh, asked the former First Service Minnesota vice president about the covenants at a neighborhood association meeting. He would not answer. A group of coworkers and I approached him at a company-sponsored event to ask the same questions that remained unanswered, and again, refused to answer, left the event. If there's nothing dodgy about these contracts, why dodge that question? Right? If they're an appropriate condition of employment, why hide them from employees? This past December, the overnight shift at Gallery Tower was eliminated and I was laid off. Looking for work, I have no way of knowing whether or where these covenants restrict my employment. And even if I did know, the existence of the covenants still limits employment opportunities and it distorts the labor market. Thank you.
Thank you for your testimony. Next up, I have Jeff Tollefson and then Tara Wyborny on deck.
Thank you,
Welcome to-
Madam Chair and members of the committee. My name is Jeff Tollefson. I'm the president of the Minnesota Technology Association. I'm here to highlight some of the far-reaching consequences of House File 3456 can and will have on Minnesota's business community and innovation economy. Companies large and small hire outside consultants and contractors for increased efficiency and productivity, allowing them to access specialized skills that might not exist in-house and the flexibility to scale as needed as projects, resources needed go up and down. But the benefits that stem from having access to high-quality contracted talent are put at significant risk with the passage of this bill. Many of you may have utilized a temp to hire or a contract to hire staffing service where you immediately bring on board talent in kind of a try before you buy opportunity. And this benefit often comes with a pre-negotiated conversion fee where all parties benefit, the company, the contracting firm, and the employee. Technology consulting firms invest a lot of time and resources recruiting skilled talent and providing specialized training. If client companies where those contracted employees are deployed have an unfettered ability to directly hire those individuals at any time, many of these consulting firms would choose not to operate in our state. This legislative intervention into established business practices will also harm our state's workforce development initiatives. Apprenticeship programs that serve as employers of record for participants on the on-the-job training element of the work would be adversely impacted. These programs play a vital role in skilling our next generation workforce and allowing unrestricted hiring of apprentices before training programs have a chance to recoup their investment will discourage the private sector from provisioning these services, putting the burden back on state-funded programs that have not necessarily achieved the scale and success as private sectors. Actions have consequences, and the unintended consequence of passing this bill in its current form are profound. We look forward to working with the bill's authors on some new language that hopefully could address some of these concerns. Thank you.
All right, thank you for your testimony. Tara Wyborny. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair and members of the committee. My name is Tara Wyborny. I am the Vice President of Talent Development for Genesis 10. I'm here to provide feedback on the consequences HF3456 will have on workforce development and the tech industry in Minnesota. Genesis 10 is an IT staffing company and consulting firm here in Minnesota with connections to many of our largest employers. Our business specializes in identifying and providing our clients with highly skilled technology consultants through contracting agreements. These contracts with our clients lay out a minimum time on contract and/or fees that will be paid prior to our clients hiring our employees full-time. Our employees can seek work at any other employer during this contract term. However, they cannot accept employment at the client they're contracting with until the terms of our agreement with the client have been met. These agreements, a try-before-you-buy model, allow us to recoup investment and make a profit while providing an important service to our clients. The impacts of HF 3456 have a broad implication to workforce development in our industry. In addition to our core service, Genesis 10 has made a meaningful impact on the tech talent market in Minnesota through Dev 10. Dev 10 was launched in 2018 here in Minnesota using the same contract to hire model. Dev 10 hires and trains diverse pools of people and provides them, or that do not have technical degrees or experience, and provides them a pathway to launch their career as software and data engineers. In order to train our employees, we have to invest heavily in wages and benefits while they are in training, in addition to building and maintaining our technical curriculum and employing a technical staff that can execute on our training. This training runs 12 to 16 weeks in length, and after that, we recoup our investment through that contract to hire model. We have trained and deployed over 400 new software and data engineers here in Minnesota since 2018. 52% of that pool identifies as diverse. Of that, 85% have converted to become full-time employees of our client site. That is the intent of Dev 10 here in Minnesota. This has driven meaningful impact to the diversity of our tech talent workforce. For Genesis 10 to continue to offer our services in Minnesota, we need the assurance that the contracts we have in place with our clients are enforceable. If they are not enforceable and the minimum terms set out in our contracts are void, our clients could hire these employees at any point in time, negating our ability to recoup that significant investment that we made in their wages, in their training, and in launching their career in technology that they could not have done without the resources we brought to bear. We believe as...
Please wrap up, and then I have a quick question.
We believe as written that HF3456 will remove our industry's ability to enforce these contract terms.
I've heard the phrase twice now, try before you buy. What are you buying?
You're able to convert a person into a full-time employee of your staff. So they're able to have them work as a contractor on their technology teams to see, hey, are you a good fit? Do you meet our cultural and technical needs on this team?
Okay, so buying people.
Yes.
Okay, all right. Thank you for your testimony. Any members of the public wishing to testify on this bill? All right, not seeing any. We'll move on to member discussion. Representative Niska.
Thank you, Chair Becker-Finn, and thank you, Representative Greenman, for the offline conversations we've had about this bill. And for this amendment, I do think it moves things a small step in the right direction in terms of clarifying, I think, or taking away one potential legal constitutional problem with this bill. And I am curious, though, about how that, and I haven't given a lot of thought to this compelled notice requirement and how that works, and whether that is subject to some sort of legal potential problem. I understand we have some other notice areas, required notice areas in other areas of labor law, but how does it work here where we're saying that a specific employer has to sort of evaluate whether their contracts come within the scope of this law and then affirmatively go and speak to particular employees about that?
Representative Greenman.
Thank you, Madam Chair, and thank you, Representative Niska. And I think it's a good question. So the reason we adopted the amendment was because of the contracting issues and existing contract. And there's sort of the balancing test when it comes to the contract clause. This doesn't affect, this says if you have a current contract, doesn't disrupt the contract, but if you have, and you should know if you have one of these restrictive employment and covenants, but your workers won't. And so like all sorts of other things we do in labor law, requiring employers to provide notice of their legal obligations under the minimum wage or whatever else. I think that this fits in that category of it's a worker notice that this contract exists, and so that they can decide and they have the freedom to decide what to do about that. As you heard from our testifier, and I've heard from lots of other folks, there's no requirement in these contracts that workers even know that they exist. They may have their employment limited, or they may have restrictions that they don't know that are happening above their heads. So that's what this is trying, the balance this strikes is saying, if you have a current contract, that language will continue, but you at least need to tell your workers about that and the legal change.
Right, Representative Niska.
Thank you, Chair Becker-Finn. Thank you, Representative Greenman, for that answer. I guess big picture, I don't think this is striking the right balance, and we've had a little bit of a conversation about this before. I appreciate the potential problem of transparency, and there's a potential problem of maybe too large of a buyout that is restricting the movement or freedom of of workers to move. And Chair Becker-Finn, I appreciate your point that using the word by in this context is at best kind of a clumsy way to talk about it. But we are talking about situations in which a service provider in the middle is really providing real value in all of these circumstances. So the worker who was here from First Service was providing an important connective service between the building and that person who might not have otherwise, ended up at First Service in the first place. When we're talking about talent providers, consulting, providing consultants, they are providing a real value of connecting people with, connecting people who want to do work with people who want to pay for work. And sometimes I have personally been a temp worker where I was aware that there would be a potential buyout if the company that was contracting for those services wanted to hire me full-time. I think those kind of arrangements are good. They are good for everyone involved. There are potential problems, potential abuses that maybe this could be more narrowly focused on. But to have a broad, no service provider may restrict, restrain, or prohibit in any way a customer from directly or indirectly soliciting or hiring an employee of a service provider, that service provider is now losing the economic incentive they have to provide that value in the first place. That economic incentive has to be built in the situation in which they're providing something akin to headhunting services, but even better in some circumstances where the customer, the company that's wanting to potentially hire them gets an opportunity to see whether that person is a rock star or whether that person is just somebody that they want to work with for a short period of time and move on. So I do appreciate at least some of the problems. I think there are some real at least potentials for abuse that we could maybe do something that's more narrowly targeted. But I think that broadly prohibiting any sort of an arrangement in which that company in the middle is prohibited from being able to set up an arrangement where they can get appropriately compensated for what they did by bringing together that labor and bringing together that company that's looking to hire that person. I think that goes too far. So I don't think this is there yet, but I do appreciate, I think the concern that's behind this bill, and maybe we can work on something that's a little bit more narrowly tailored and actually gets at the problems you're trying to solve. Thanks.
All right, thank you. Representative Frazier, Vice Chair Frazier.
Thank you, Madam Chair. Thank you, Representative Greenman, for bringing this bill. Do we have an idea of how many of these shadow compete clauses are out in the state of Minnesota?
Representative Greenman.
No, and that's part of the problem. We didn't actually know that this existed until, one, as you heard from our testifier, they read about it in the newspaper. When we brought this bill, we heard from a set of other industries that are relying on them. And so that's part of the problem. Again, we said and had an open conversation about non-competes, and at least with those, workers were signing a contract with them. But because of the impacts they had on mobility and the free market for labor, we got rid of them. So in this case, we don't know. Oftentimes workers don't know, and that's part of the problem.
Vice Chair Frazier.
In situations where we may have learned about these, have there been moments where there are other opt-out clauses in any of them?
Representative Greenman.
So some of these clauses are structured as, and there's some very broad prohibitions. We saw one in the childcare industry, which not only prohibited hiring or soliciting during the day, but hiring or soliciting the worker at any time for any work, including 180 days after they worked there. And some of them have, as I think Representative Nisko's alluding to, like some of them have monetary clauses that will say, but again, they're monetary clauses not with the worker, with the customer that says if you hire someone, it's basically a liquidated damages idea. And so those are, you sort of see it different ways, but most of them are pretty high, and they appear to be as much about restricting that transaction as they do about recouping those costs.
Vice Chair Frazier.
Thank you, Madam Chair. Thank you for that answer. I mean, I too would kind of tweak my ears when I heard the try before you buy, because what I hear with these kind of shadow covenants is you're putting shackles on workers and you're restricting their ability to move around. I understand the work that some folks are doing to train people, get them the skills that they need to provide those workers, but I also understand what it's like to be a worker and to not have the opportunities to move up or move on And this seems like something that we really need to address.
Thank you. All right, Representative Scott.
Thank you, Chair Becker-Finn. I just wanted to run a scenario by you, Representative Greenman, and thank you for our visits on the House floor on this bill. What about a scenario where a service provider, I think that's what they're called here, right? A service provider connects a graduating high school student who's interested in being an electrician, says, I have an employer that will pay for you to go to school, get your electrician's license, and pay you to be an intern during that period of time, and then afterwards, you're obligated, they'll provide you a job. After you graduate, you're going to graduate debt-free, and afterwards, all they're asking is that you remain with the company for 4 years so that they can recoup their costs. Would this bill prohibit that connection from happening legally?
Representative Greenman.
Thank you, Madam Chair. I think as I hear your hypo, it is which brings me back to law school. It is an agreement between the worker and the company. This is actually not about and doesn't impact relationships between workers and companies. These are about contracts between two people above the head of workers, unless I misunderstood you clear. So if if what you're saying is you have an agreement with a worker, you're going to pay their education, and then they're going to have some sort of employment agreement. This doesn't impact them because this is about two service providers above their head.
Representative Scott.
So, thank you, Chair Becker-Finn. So what if that's all put together by one of these third parties? What if that whole arrangement, this company will pay for your schooling, the whole 9 yards? They're the middleman. They're a service provider, right? They are connecting that potential employee with a potential employer. And the potential employer has hired this third party to say, hey, will you connect with, graduating high school students for us and offer them this deal?
Representative Greenman.
I think that the reason I'm struggling with this hypo is the question is who is doing the employing. If you have a business model that relies on restricting worker mobility and the free market of labor, that's a problem. Like, that's the problem we're trying to solve. If your model is linking somebody with the employer and then getting compensation back from that person, that I don't think should be a problem.
Representative Scott.
Chair Becker-Finn, I don't know if we're following on each other's wavelengths
Maybe
here,
not.
but I wouldn't see that as necessarily, in that scenario, I wouldn't see that as restricting an employee. If they sign a contract saying that they're obligated to work for this company, XYZ, for 4 years, but they've been given all this training and expensive education, to me, that shouldn't, they should be obligated to fulfill their obligation. So maybe we can talk offline, but that's, I just don't want to, in a scenario like that, I don't want to, when we have a need for qualified people to work in different industries like we have in the trades or anything really, tech industry, I don't want there to be something in the way of making that happen for people. Because it's furthering their education and putting them on a trajectory for, a good future and a good career. So I don't want anything to stand in the way of that. Thank you.
Representative Greenman.
Thank you, Madam Chair. And I think, if the person signing the contract is the worker, this is not the bill that impacts that. Because what this is about is two, above the head of the worker, two businesses or whatever sort of relationship people are in, making a decision that restricts the service provider's employee. And so, and I think, again, if you have a business model that relies on restricting that person's ability to to get another job, even if it is with the customer. I think that that's a problem and to what Representative Fraser said, because it does actually limit the choices of that worker. It limits their opportunity to have a better job, better wages, maybe in a better environment. What we heard in testimony in the Labor Committee was folks who, the HOA wanted to actually keep their front desk staff, their janitorial staff, and when they went with another service provider, they couldn't, because the employee wanted to stay, the HOA wanted them to stay, and the service provider had this restriction in their contract. So that actually hurt. The HOA wanted to keep that person too. So we haven't been talking about this, and this isn't the root of the bill, but there's also a restriction on markets for other competitors issue here too. But again, this is not about contracts that are made directly with workers, and that's part of the problem.
Seemed like a pretty good wrap up, but Representative Greenman, if you want to say any more to wrap us up.
Yeah, I would just say, and I agree with the committee that I think people are not products that you buy and sell. And so when we talk about workers and sort of the dignity of work, but also the free market of labor, that's what this bill is trying to do. So with that, Madam Chair, I would ask for your support.
All right, I will renew my motion to recommend that House File 3456 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? No. Motion prevails. Thank you, Representative Greenman.